This is LXBN TV, and I'm Colin O'Keefe. The Responsible Corporate Officer Doctrine is an unforgiving rule that can have career-altering consequences for corporate officers who allow misdeeds to happen on their watch. To explain the doctrine and how it's been applied recently, we bring in Eric Reed, partner in Fox Rothschild's Philadelphia office and author on the firm's blog, the Securities Compliance Sentinel. Eric, first off, what is the Responsible Corporate Officer Doctrine and how did it come about?
Hello, Colin. Thank you for having me on the program. Responsible Corporate Officer Doctrine is a mechanism for charging corporate officers with a strict liability misdemeanor crime for an offense in which they not only did not participate, but also might not even have known about. I'll break that down a little bit to explain it some more. Most crimes involve both an intent element and a conduct element. A strict liability offense, which is what we're talking about here, has no intent element. So the best example is like a speeding ticket. You may have had a similar experience as me when you try to talk yourself out of a speeding ticket with an officer. The officers generally do not care that you did not mean to speed. If you're speeding, you violated it, whatnot. That is a strict liability offense. Responsible Corporate Officer Doctrine takes that even a step further. In responsible corporate officer situations, the responsible corporate officer not only did not participate in the speeding, to use the example, but may not have even known about it. The only defense available in that situation to an officer that's caught in that situation is to prove that it would have been impossible for the officer to have prevented the actual occurrence, and that in and of itself is a nearly impossible burden to match. The rationale for responsible corporate officer doctrine is that the people in the corporate suite of an organization ought to have sufficient familiarity with the operations of the other business units and be sufficiently in touch with those operations to detect and prevent the misdemeanor crimes with which they have been charged.
Yeah, exactly. It makes sense that the burden then would be so hard. You're in charge. How could you have not prevented something like this from happening? So, exactly. Second, how has this been applied recently, speaking specifically to a July ruling coming out of the D.C. Court of Appeals?
Well, recently, the D.C. Circuit issued a ruling partially affirming and partially reversing and remanding a result involving Purdue Pharma and specific officers of Purdue Pharma. Purdue Pharma and some of its officers have been charged with misbranding the drug OxyContin. The misbranding in particular had to do with the marketing of OxyContin as something that was less addictive than some of its competing drugs. The company was charged with felony misbranding, and the individual officers were charged with misdemeanor misbranding. And this is one of those misdemeanors that is a strict liability offense. So if the drug was misbranded, you're guilty. There was no real defense that I could tell available to these officers. So they were in a bad situation. They ended guilty pleas to the misdemeanor, perhaps expecting some form of leniency. And that was the end of the criminal situation. The real repercussion for those individuals came in the regulatory setting, where the Department of Health and Human Services followed up with a 20-year ban of those individuals from participating or being employed by any entity that does business with the Health and Human Services, to sell to Medicare, sell to Medicaid, which most pharmaceutical companies would like to do in order to make money. It was just a horribly debilitating consequence for those individuals. The intra-agency appeal cut that back to 12 years, but the individual still challenged that through the court system, and it went up to the D.C. Circuit. The D.C. Circuit essentially said that the agency was within its discretion in banning these individuals, but remanded it back down for a better explanation of why a 12-year ban was reasonable. The statutory minimum or default is 3 years, and I think the highest prior ban was something like 10 years. So this was quite a departure, probably driven by the volume of sales of OxyContin that occurred during the offense period.
Finally, and you outlined some of these in your post, what lessons does this case hold for other corporate officers?
Well, I think there are several lessons here. First, ignorance is just not a defense anymore for corporate officers, at least in the situations where they could potentially be charged under the Responsible Corporate Officer Doctrine. The individuals that were charged in the Purdue Pharma case probably had nothing to do with the actual marketing of the OxyContin. In this case, they're sitting over in a corporate suite. They're not embedded with the marketing units or the other related business units, yet they found themselves charged. The second, and I should add that those individuals included the former general counsel of the organization. So in-house counsel are not immune in this situation. The second takeaway is really just the tremendous collateral consequences that could exist as a result of even a misdemeanor charge. None of these individuals were likely facing jail time, or if so, it wouldn't have been particularly significant. Yet the bar that they each faced as a result was really tremendously damaging to their careers. So in that situation, as defense counsel, when you know that you have this potential liability out there for your client, your job and the best win you can get for your client is to convince the government not to bring the criminal charge in the first instance in order to avoid those collateral consequences. This really speaks also to the tremendous discretion that the government has in a situation. And again, your role as counsel is to try to convince the government to exercise that discretion in your client's favor. Finally, I would say that this situation really underscores the need to have a well-developed and robust compliance program that has strong support from the top of the organization all the way down, so that people in the corporate suite perhaps don't find out after the fact that events that could give rise to liability under Responsible Corporate Officer Doctrine have occurred.
Interesting. Yeah, I mean, once again, it's turning a blind eye just isn't going to work in these types of situations, and corporate officers need to be proactive in making sure that everything is in order. Well, once again, that was Eric Reed of Fox Rothschild. For more of his insight on the subject, be sure to visit the Securities Compliance Sentinel at securitiescompliancesentinel.foxrothschild.com. Many excellent authors on that publication. Fox Rothschild is probably their very best one. It's excellent, so be sure to visit that for sure. And for more LXPN TV interviews, visit us at lxpn.lexblog.com. Thanks, Eric.
Thank you.